Good morning, Chattanooga. Welcome to Legal Bytes. This is Jim McCoon, and with me is Clay Whitaker, and we welcome you to another edition of our show. And Clay, how are you doing today?
Doing great, Jim. How are you?
I'm doing fine.
I lost my microphone there for a second.
It's a beautiful fall day, and I'm enjoying the weather. I like the crisp air and the breeze. It just feels so much better than that hot summer we're going through. But you know, one of the things that I want to try to do today and start trying to work it in is a little bit of change of format for our show. There have been several requests made here to the station that, and I guess backing up, we've approached this show as an opportunity to basically educate the public and to do a public service from the standpoint of choosing an area or a few topics for an area to discuss, to educate, you know, the businessman or the family on risk management, on estate planning, on various issues that they may face. And apparently there have been some requests made to the station that we avail ourselves to callers who want to just ask a lawyer a question that may not be on topic. And so they have felt that, you know, they couldn't really call in and ask the question that they wanted to ask because maybe we were talking about estate planning that day and they wanted to talk about their daughter's car wreck, those kind of things. So I want to try to provide a time during the show or at any time during the show that listeners want to call in. Our number is 423-800-8949. That's 423-800-8949. And please don't get confused. 800 is not the area code. This is not a toll-free number. It's a local number. So it's 423 first and then 800-8949. But I want to make that available to all the listeners. It doesn't matter what topic is that we're talking about on the show or Clay is opining, as I often ask him to do, about. But if you've got something that you need to talk to a lawyer about or you just want to find out an answer to, please feel free to call us and we'll try our best to answer. And if we don't know the answer, we'll try to have the answer for you either off the air or at our next show.
Or we'll make it up as we go along.
My wife says I do that all the time.
Well,
but
anyway,
we
do have a topic today. Even though this is free radio, call in all you want to. We'll talk about any topic. We do have some topics. We want to talk a little bit about gun control.
And the First Amendment and the right to protest. Those are two topics that are huge right now in the national media. And I think I'd like to go in order of the amendments. So let's talk about the First Amendment.
Okay, that's great. Let's do that.
Yesterday, I don't know, those, especially if you watch and read the sports sections of the papers or the internet, yesterday there was a huge meeting, and it was huge not because of the size, but because of the import of the meeting between Goodell and the NFL Players Union, a few of the owners, and a few select players. And they met yesterday for 2 hours to talk about numerous issues. And they would not say it was limited or that even they discussed the current protests that are going on with respect to the flag and the Star Spangled Banner. But they met to talk about the platform that the NFL provides for the players and for the owners to make a statement and cause social change in America. And basically, as I understand from the tweets that have come out from that meeting, is that the owners have basically told the players that they think they're patriots for standing up for what they believe in, regardless of the ridicule or the possible effect, and that this is not an NFL issue. Social change is not a player issue. Social change is not a team issue, but it's an American issue. And so they want to find a way that they can best use the NFL as a platform for affecting that. And so there you've got a situation where basically the employer and the employee are trying to work together because of their prominence in the media to do things that would effectively be a protest. Now, that is rare. very rare. Normally you have a situation where individuals take a stand about what they see as the problem. And then the question comes up, well, can they carry out their personal feelings and their positions in the employment workplace? Now, isn't that the way you've seen the issues?
I think it is. I think that's one way to look at it. Now, it depends on your where you fall on the political spectrum too, I think, Jim. So it's really curious to me that you have a collection of billionaires and a collection of millionaires, those being the owners and the players, who have entered into this disagreement that they have about their rights to express themselves, particularly related to the First Amendment, and then how that ties into your workplace. So, for instance, the average person today, I don't think anybody would believe that you could go to your workplace and decide to make a protest on your employer's time about whatever particular issue it might be and not have some sort of consequences that resulted from your actions.
Absolutely. I mean, and those players, when they're out on the field and they're kneeling or sitting or doing whatever they're doing in protest of, I think it started out to be police violence against blacks and the Black Lives Matter movement. Then it turned to protesting against Donald Trump because he said they were un-American. I'm not sure what the protest is today, other than just a sign of unity. But they are on the job when they're out there doing that.
Well, I think that is the sort of thing that sticks in the craw of most Americans, is that the view of what could be considered America's pastime, that is watching professional football, is now being tainted by the political discord that we have. And, you know, whether you're a person that supports President Trump and his group, whether you believe that's the Republican Party themselves or some other smaller group of the Republican or conservative movement, or whether you're a part of Black Lives Matter or the Democratic Party, you know, that sort of drifted now into the mainstream of our culture, including the football, and that's a problem for most people. So I think that's what's really got folks up in arms.
Well, that and because of the way it's now lining up, we're not talking about any particular social injustice. We're talking about the First Amendment. And that's why it came up as such a topic for us today, because it's not whether or not, you know, I'm against police violence or I believe in supporting Black Lives Matter, or I just think Donald Trump is a chauvinist and shouldn't be telling us what we have a right to do or not do. It's now purely, do I have the right as a citizen to take a knee if I choose to and express my feelings individually about how I feel about whatever it is?
Well, Jim, let's call out to our listeners. This is Legal Bytes. The number is 800-8949. That's a local call. Give us a call. You can talk about any topic. We're here talking about the First Amendment right now in this half of the hour. And Jim, I wanted to ask you, so the term, the First Amendment, at least it's two parts to the First Amendment. One of the parts, though, is that we have the freedom of speech. The other part of it deals with the Establishment Clause. And so we're not talking about that today. We're talking about whether or not people have the right to unlimited free speech. And that's not really true in our country. Free speech is limited, and it's limited by the categories and about the government interest involved in limiting that speech. Is that right?
Yes. And I think every right of an American citizen is limited to the extent of being reasonable. And for example, and the example everyone gives is you can't walk into a crowded movie theater and yell fire. I mean, that's certainly a right to free speech. But look at the impact and the safety and the concerns you have for all the citizens if there's not a fire. Oh, I see we have a call. Hold on one second. Let's see if we can get that. Welcome to Legal Bytes, caller. Do you have a question?
Actually, I don't have a question. I have an observation on the deal with free speech.
Yes, sir.
I think the problem is that we're misconstruing the Constitution like we are in so many areas of it. We're not talking about free speech. We're talking about freedom of speech. There's a big difference. If you go and study the Constitution, freedom of speech is a controlled speech. And how do you know that? Because when you go back and you deal with the preamble to the Constitution, the founding fathers address all the issues with the King of England as to why they're going to declare a new country. Because they were not allowed to address all those issues to the king privately.
Okay. Well, even taking the position of controlled speech, certainly what the the players are doing on the field is controlled, it's not disruptive, it's not causing issues, does that fall within the amendment as you construe it?
I think it is controlled speech because they're not going to the source of the problem. If they want to address the issue of either Black Lives Matter or the killing of black men by white police officers, or however the situation goes down, they need to go to the place where it happened. And they need to address that on the level where it happened and deal with it there.
Well, we've got 32 NFL teams in 32 different cities. So surely in at least one of those 32 cities, it has occurred. Let's say Chicago. Chicago has been well known for some of the violence that they've been finding with the police officers. So should the Chicago Bears be able to take their knee during the national anthem?
No, I do not think they should be able to take the knee. I still think it goes to the issue of controlled speech, disciplined speech. If you're going to deal with it like the founding fathers did and the original people did under the Constitution, you draw up your grievances. You address the issues as you see them.
Well, under your interpretation, though, there would never be a right to protest. We would not have had the massive change.
That's not true. We have a right to protest. According to the end of the Constitution, we have that right. If our grievances are not met, then we have the right to protest.
Okay.
But we even do that in a controlled manner. Right. Because if we don't do that in a controlled manner, then it becomes anarchy and the other things. And then you push the government to the place where they actually can declare martial law. You have to be very careful about that.
I agree with that. You have to have a license even to do a march.
Or you have the other end, and that is you end up having a civil war or you have a revolution over it.
Agreed. So you think that the players then are protesting, and they're protesting in a reasonable and controlled manner when they're on the field?
No, because that's what are they addressing? They're just putting their knee down. And they're making everybody being responsible for that, but the issues that they're addressing are not going to directly what they're saying that they're addressing. I mean, I just think one size fits all is not the answer.
I understand, and I think where they're frustrated is that redress in the courtrooms, redress in the town halls and city halls are not reaching. See. And so what these players are doing is they're trying to bring attention to the problem and make it so uncomfortable that someone takes it up and addresses the problem. I think that's where the players' position. Now, I disagree with what the players are doing, but I see their side. And that's what they're doing is they're taking the fact that they are heroes, national figures, public figures, and have a big platform and using that platform to try to affect social injustices. That's their approach. But caller, I appreciate your thoughts and comments, and thank you very much for the call. Please call again.
Hey, thank you.
Yes, sir.
Well, Jim, that caller addressed one of the issues, and that is the quality or the characteristics of the speech. Looks like we got another call.
Yeah,
Jim.
we got another call. Hold on.
You've opened up the floodgates.
Yes, this is Legal Bytes caller. Do you have a comment or question?
Great topic. There's always going to be issues to protest. Always, always, always. Years ago it was state lines, and should we ratify this part of the Constitution? Shouldn't we? If we're going to use that as the litmus test, why don't we protest government because Bill Clinton murdered 76 innocent men, women, and children in Waco, brought in the military, and just burned them out and killed them for no good reason, because government are murderers. But let's remember, this is a private organization. The First Amendment only applies to Congress, and through the 14th Amendment, it's political minions. Everyone from the dog catcher to the president is bound by the 10 Amendments. It says Congress shall make no law. Congress. And through the 14th Amendment, that also means your local officials, but you already know that. When it comes to the NFL, they're at work. You can't at Subway take a knee. I'm sorry. They wouldn't even allow the players to celebrate at the end of the field. These are a bunch of disrespectful, ignoramuses, ignorant, overpaid little boys that really don't even know what they're protesting. They have no clue. They just want to protest. Now, we know Colin Kaepernick was a Marxist. He loved communists, like most Democrats and people that backed Barack Obama do. But the point is, if you want to kneel for my flag, they are fighting words. It was a 5-4 decision that the Supreme Court allowed people to burn my flag. And that restriction is against government, because if anybody burns the flag in front of me, if I'm driving, I'll probably run them over. And if they're in front of me, I'll probably punch them in their face. Because I'm not bound by the Constitution. Government is.
No, but you are bound by hate crimes. We all have hate crimes, caller. And so from that standpoint,
there's no such thing as a hate crime. That's ridiculous. That's a government-made-up term. The fact that there's a crime denotes it's hate. That's absurd. That government passing a statute calling it a hate crime is ridiculous.
Well, no.
How are you going to prove that?
Caller, what you're doing is you're saying anyone who doesn't agree with you is ridiculous. Anyone who doesn't agree with you is taking a ludicrous position. And it doesn't work if you try to talk over me. Unfortunately, this is our show. So don't talk over me. My point is that I understand and I respect your position and your feelings towards Colin Kaepernick, the NFL players, or anything else, and what they may be doing. Unfortunately, several of those men are very educated, are very well respected, and have positions and are trying to use their position to affect social injustice. There is social injustice.
And they need to do it out of the workplace, because I'm sure if somebody at your place of business decided to take a knee, you'd probably fire them or say, listen, that's not professional. They're not being professionals. If anyone has grievances against government, it's me. The individuals elected and are hired to oversee and perpetuate the growth of this welfare state. But I'm certainly not going to disrespect that symbol that men and women died for.
Well, that flows in.
To me, they're fighting words. That's tantamount to calling my mother a whore.
Well, those are separate issues, and I agree that there are separate issues as to whether or not you can use a platform of an employer to as
but
a.
Jim, I'll tell you what the great thing about this is. Now the left, and that's the great thing about Barack Obama. We're smoking out the rats from under the porch. When I was a kid, we used to smoke out the rats and shoot them with 22s. They were hidden for so long. The Lindsey Grahams, the John McCains, and all the left, they're being smoked out. They're done. I can tell you, the NFL is done. I know your radio station pulled it. They're done. Their Marxist agenda for the past 100 years is over. We're retaking this country, hopefully peacefully.
Well, I appreciate your thoughts and comments, and thank you for your call.
All right, thanks.
You know, Jim, our last two callers bring up the point about the relationship between government and free speech, but it doesn't really discuss the issue of the way that the First Amendment applies. That caller was correct in the sense that the government restrictions on the freedom of speech are the issue that at least our profession deals with.
Right. I mean, what the private, you can't walk into Park Ridge Hospital as a nurse and decide that you're going to do something in the middle of a war. I mean,
that's
because of your political positions.
And so, the issue related to both of those callers has to do with the nature of any restrictions that are on these players, where the restrictions come from, and whether or not that in any way has any governmental aspect to it. I mean, I could see, for instance, you and I talked earlier before we started the show about the protest back in 1968 with the United States Olympic team, and that there were protests, and I believe that the government,
was the Black Power Olympics. That's what they called it.
And there might have been the ability for the government, and it might still be for the ability for the government. Let's say that the next Olympics are ones where black athletes decide, or white athletes decided that they were going to protest a particular issue, and we're going to restrict the ability for those athletes to make that protest, or that they would not be able to participate in the games. And if they did those things, we might be talking about a different kind of response, and what the First Amendment, how it was actually impacted in this kind of case.
Well, and that's right now what the NFL is grappling with, is because currently under their protocols and rules and procedures, it says that a player should stand for the national anthem. It is not mandatory. It is not required. And so those that have chosen not to and are not doing it but in protest are not really under any governance that they're violating under the NFL rules for the players that play for the organization. So, if Goodell and them decide to make it mandatory that you stand, labor, because they're under a labor agreement with the players, has indicated that it's going to file an action before the NLRB because it's inappropriate. It wasn't bargained. And so they're in a real contention right now as to whether or not the NFL can do anything unilaterally to force its players to do things because it wasn't already in place.
Well, and I think that's kind of where we come down to. These are issues that relate to either the contract that the NFL players are under or the state law that talks about whether or not you can be restricted on employment in some way. And so you might ultimately, let's say Colin Kaepernick, I believe that he's filed an action recently indicating that he believes that there was collusion between the league and the owners to prevent him from being retained as a player in the league. Consequently, I think you might be able to make out lawsuits regarding any restrictions that may have been placed on him or that he might have been in some way targeted or singled out as a troublemaker. And so he can't work in that field anymore. That's really a labor issue. And I think ultimately that's what's going to happen in this case is the decision making is going to be about whether or not the league has the ability to restrict the players based upon the NLRB contract and in regards to whatever the state law might be.
I agree. But then let's go to the common man and woman that work in a Tennessee employer. What rights do they have? What to do anything that would be considered political speech while on the job?
Well, it's curious too that people conflate many of these things. Our citizenry does.
Conflate?
They conflate. That's a big word.
Yeah, it is. I'm from South Georgia. What does that mean?
They mix it all together in a mishmash. That helps you, doesn't it?
It does.
All right. So the mishmash.
It's like a bowl of grits.
Yeah, pretty much. Put it all in there, mix it all together. Complaints that, hey, you can't burn the flag or you can't, not take your hat off at the singing of the national anthem, or if you're going to say the Pledge of Allegiance and somebody didn't want to do it, well, you can't do that either. Well, the fact remains there's nothing in our laws. And in fact, if you'll look in the United States Code, there are guidelines about how you should observe the singing of the national anthem, whether there is a flag present, someone not present, how you're supposed to attend to yourself during that time, if men are wearing hats, what they should do, and how you're supposed to show honor to the flag and to the national anthem. But, there's nothing that requires it because you can't force people to honor these national symbols.
Right. It's just like the flag is supposed to be taken down at sunset.
That's
and
right.
There are so many places that leave the flag up once they put it up forever.
They drag it on the ground, they leave it out, those sorts of things. And so you can't necessarily mix all this stuff together. You've got to look at it in terms of what the law would say. And it looks like we're almost at the end of our half hour. And, this might extend into the next half hour. I don't know.
I think we've hit a nerve in the public. I know I find it very interesting. And I want to talk about the employer who tells his employees, you cannot honor the flag. I am protesting and therefore all of you are prohibited from honoring the flag. Can that be enforced against the employer?
Let's talk about that in the next half hour.
And this is Legal Bytes, and we'll talk to you after the news and the half hour break. Thank you for listening.
The Tennessee Valley's news talk leader, Nooga Radio, digital FM 95.3 HD4 and 92.7 FM. 3, 2, 1. Chattanooga Radio, digital FM 95.3 HD4, 92.7 FM's news now.
A trial date has been selected for Benjamin Brewer, the man accused of killing 6 in a deadly traffic crash on I-75 at the Ottawa exit a few years ago. Monday, January the 22nd is the date. Jury will be selected the prior Thursday. There was a bit of a roadblock in this trial as well. A methamphetamine test from the state tested higher than the federal test did. Judge Don Poole has allowed for the federal test to be used by the defense. It's been decided that the Grundy County football team will complete its football season. An interim head coach has been picked. Nick Meeks will serve as the head coach, with the assistant coaches holding their regular positions. Phase 3 of the plan to move the Chattanooga airport off-grid is continuing. Now all the airport needs is a federal grant. They've hired a consulting firm for $75,000 to assist with the grant application. Russell Stroud, Nooga Radio News Talk 92.7, now.
Traffic, news, and information. Nooga Radio. Digital FM 95.3 HD4 and 92.7 FM.
Nooga Radio 92.7's fast forecast now. 67 degrees in Chattanooga and sunny. 81 for our high today, 57 for the low. Overnight clear, 65 as we start to get into our morning tomorrow. Tomorrow, partly cloudy, 84 the high, 65 for our low. Nooga Radio 92.7 and 95.3 HD4 is the home of Sean Hannity every weekday from 3 to 6. David Tulis Show, 9 to 11 mornings. That's your fast forecast. Now.
The Tennessee Valley's news talk leader. Nooga Radio. Digital FM 95.3 HD4 and 92.7 FM.
Your marriage is over. You've been abandoned, betrayed. You're angry, shattered, and heartbroken. Don't go it alone. When you are facing divorce, you need an experienced advocate to help protect your rights and future. And you need it from a man with a sympathetic heart, but a hard nose. Attorney Clay Whitaker will fight for you in this most confusing and bitter time in your life. Clay Whitaker, 756-6400.
Nooga Radio. Digital FM 95.3 HD4 and 92.7 FM knows your opinion is important. So call 800-8949. Agree or disagree. Call 423-800-8949. 800-8949. Nooga Radio. 92.7 FM and 95.3 HD4. News Talk Nooga Radio.
Welcome back, Chattanooga. This is Legal Bytes with Jim McCoon and Clay Whitaker, and we welcome you to the last half hour of the show. And Clay, you and I have obviously stirred up a hornet's nest with respect to this First Amendment issue and political speech and its effect in the workplace.
I think so, Jim. And I think many times this kind of thing really hurts people's feelings. They have a lot of pride in the flag, particularly our area. You know, Chattanooga is one of those few places that still has recognition by parades of Veterans Day, Memorial Day, and those sorts of things. And it's important for us to remember, you know, those servicemen who have given the greatest sacrifice, and that's really disrespectful to them. And I think that's what really gets to people and why this has become such a hot topic.
I agree. And it's, you know, that's one of the wonderful things about our community is we still are a very patriotic community. And a lot of our old time values are still held today. Oh, we've got a call already. Hold on a second. Welcome to Legal Bytes, caller. How can we help?
Yeah, I don't normally call back twice, but I needed to clarify what I meant. But you guys sound great. I love this topic. I think if Congress were to pass a law restricting speech or compelling speech, or even a local government, state government, that would be obviously unconstitutional. But what we're addressing here is a political entity called the NFL that also opposes the Second Amendment. When players wanted to put a symbol on honoring the police in Dallas, they said no. The NFL is a political nonprofit entity. They can do whatever they want. You know, if they want to kneel, let them kneel. But the point is, it should not be accepted by ownership or management. If they did that in my place of business, they would be fired. Period. This is a private organization. The NFL is a non-profit private organization, and I'm putting that in quotations. But that the management tolerates this with these little boys that are playing a kid's game, to me is intolerable. Because, you know, if you read the Supreme Court decision on that 5-4 decision on burning the flag, and I think you have a right to burn the flag, but it's like calling someone a name or calling their mother a name. They're fighting words, and fighting words incite violence. So just expect that if you kneel for the flag or the anthem, or you burn my flag, you're inciting violence, and it may cause violence.
Well, caller, one of the questions I'd have for you is this. So let's assume that President Trump decides that he wants to take the view that the television broadcast are really the use of a public utility. And so he says to the FEC that if you want FCC, that he wants to make sure that there can't be any unpatriotic broadcast information, and he cuts out or blacks out or blanks out that segment where the players are kneeling.
Blatantly unconstitutional.
You think
government
you think
has no say over what can or cannot be on the radio or television. But let me tell you this: they should look at the licensing of these networks because, and I can tell you this is a fact. Broadcasters are bound by the rules that compel them to operate in the public interest and operate honestly. They cannot use deceptive practices in their broadcasts, which means newscasts that are deceptive when they say, hey, look, and they were caught doing this. We have an agenda here. We're going to set the agenda. And I think we should look at not licensing those entities like CNN and the rest of the operators that do not operate in the public interest and that are purposely deceiving the public.
Well, caller,
giving the public interest.
You know, I believe this station, and I know it runs NASCAR on weekends. If NASCAR drivers started kneeling or carrying symbols on the sides of their sleeves that had the flag with an X through it, or did something to show using their platform as a form of protest, do you think this station should stop running NASCAR?
Not only should it, it would.
Well,
and stop running NFL. It not only should, it would.
Caller, let me ask you, I don't know if you're old enough to recall this, but you recall back, used to be in the live wrestling days back in the 70s and 80s, there was a Iron Sheik, and he used to come out with his flag, and he'd take the American flag, and he'd throw it on the wrestling mat. He'd stomp all over it. He'd spit on it, throw it out, and burn it. Would it have been one of those things appropriate for us to have censored them also and cut them out?
No, I think censoring should be individual. The government has no authority to do it. Under certain circumstances, they do. Reverend Carl McIntyre in 1968 in Pennsylvania from Red Bank lost his license. The Federal Communications Commission pulled his license under the Fairness Doctrine, another clown piece of legislation that was ruled unconstitutional implemented by the dummy rats, the Democrats. He lost his license because he couldn't find the opposing point of view to promote communism. He was anti-communist, and he couldn't get the opposing point of view. So under the Fairness Doctrine, they pulled this guy's license. I've never seen a liberal entity's license pulled. And you know why that is, Jim? Because we live in a socialist liberal country.
Well,
want to promote these views. And you keep people socialist activities by keeping them stupid. And one of the things I've challenged lawyers to do for years, there is no law compelling anyone to file a tax return. It's voluntary. But if you don't file one, and it showed that you thought you had to file one, the willful failure to file. Yet there's no law compelling you to file. Figure that one out.
Okay. All right. Well, caller, we're getting a little off topic, but thank you so much for your call. Appreciate it. Well, Clay, we've given him a good platform.
Well, I think so, Jim. And those are sort of the opinions many American citizens have about these issues. And so I'm glad the caller called. Thanks so much, caller, for calling in and having this on-air debate with us about this issue. So,
right. So where I'm going, though, is we're really talking about protests. I mean, that, you know, it's a freedom of speech issue. It's a freedom of political speech issue, but it's really a protest.
And political speech is the most protected speech in this country. So we make sure it's enshrined, and the government has to have a compelling government interest to restrict it.
Okay. So from that standpoint, how can we restrict political speech? We do that every day. Let's talk about Richmond and what happened in Richmond. That was clearly political speech in the beginning of what was supposed to be occurring. Correct?
I would agree with you.
So where did Richmond go wrong? What can we do in this country to restrict political speech and still not violate the Constitution?
Well, I think it's going to be difficult to discuss Richmond. Here's the problem with it is that ultimately ended up with a situation regarding public safety. So you had the ability. But
isn't that always the question with political speech?
I think so. It can. But I mean, in this particular instance, what happened was you know, in Richmond, that there was a group that required the permit. They actually had the permit. There's questions about whether these other groups actually had the permission to be there. And, you know, the police officers there in Richmond, or if you want to go to Charlottesville, did not protect the group that actually had the permission to do the protesting. And so as a result of that, you ended up with this conflict, and it shut down.
Charlottesville turned into a mini war.
It did.
Really.
That's exactly right. And it sort of, so you've got to have the cooperation with a governmental entity to provide the protection to allow you and to believe that you have the right to protest. I think that's really one of the issues that we've got now, is that the dominant culture in our nation now is more of a liberal postmodern culture. Consequently, those that hold traditional views are shouted down, not allowed to express their views. That's the danger we face now, is that the liberal modern society doesn't allow the traditional society to express itself. So those people who are trying to express themselves, as in Charlotte or in Richmond, are being shouted down. The question is here, are we able, in regards to the NFL protest, to protect this speech, to allow it to occur? I think it can be protected and is protected by the NLRB contract and by the state laws that currently exist. I think the problem that the NFL people are going to have ultimately is that their viewership is going to drop off, and whether or not this actually has an impact upon America's pastime.
Right. And that's why I think what the players have done ultimately got the attention from the NFL, because it's hitting them in the pocketbook.
I think you're right.
I think that's what's really driving any conciliation between the owners and the NFL organization is money. It has nothing to do with for the owners or for the organization to try to affect social justice or injustice. I think what's going on is they're seeing a potential attack upon the shield, as the NFL always refers to it, and they're trying to protect the shield, and that's an economic protection, and that's what we're seeing happening.
I think one of the ways to look at this, Jim, is just what I brought up before, the live wrestling example, is that those are protests that were allowed by certain caricatures that were effective, at least at that point in time, to raise the ire. As it always is, you got to have a foil in your sports. So you have the wrestling foil, someone that the viewer hates and then wants to see the good guys come and beat them up. Now, if that's one way the NFL could work this out, there's some allegations that they're fixing games now. So what you have is the NFL would support the teams that wanted to defeat the teams that were at least not liked very much by the viewers. That would cure their problem. Now they could hire us and we could solve that problem for them, Jim, but apparently they're not wise enough to do that.
And callers, if you have a comment on these issues that we're discussing today, or if there's just something off topic that you'd like to discuss, please feel free to call us. Our number here at the station is 423-800-8949. That's 423-800-8949. And this sort of transitions into another topic that I wanted to talk about. You and I discussed before coming on, and that was a Second Amendment issue that's come up. Hold on a second. We've got another call. Welcome to Legal Bytes, caller. Can we help you?
Yes, I have two questions, both about expungements. Would you be able to help me?
Sure. Go ahead.
If you get a ticket, say, for failure to have your insurance card in the car, they write you a ticket, and you go to court and you prove you had insurance, and it gets dismissed. Can you somehow get that removed to where everybody that looks at your ticket history doesn't see it for the rest of your life?
Well, what do you mean when you say ticket history?
Like a citation for financial responsibility.
Okay. Well, so let me explain to you generally how this works. This is Clay Whitaker, and one of the things that you'll find is that you're talking about whether or not you have a record created for your criminal convictions. That's the first part of it. Then the second thing, whether or not that sort of violation is a crime. And then the third thing would be whether there's some other record that's created. Now, I'll go through those things as I've listed them. So the first part of it, yes, there can be a criminal history created, and the criminal history is kept locally and is also reported. There's various reporting agencies, but the primary one for most crimes, and this is probably not related to your particular questions related to a driving offense, is that most crimes are going to be local, and they're not going to be reported to the National Crime Information Center. And so ultimately what happens is that you get that dismissed, you can have it locally expunged, and it will not be on your local record. Now, is there going to be another record that's kept? What people don't really understand today is that there are a number of private entities that are collecting information, primarily for, you might guess, insurance companies or companies that relate to making decisions on employment. LexisNexis is one of them. There's some other ones. Basically what happens anytime that there is a arrest record created, those private companies come and take that information and keep it. Consequently, is there a record of that you can get rid of? And the answer is no. So these private entities, let's say you had a background check done, or that you were looking forward to trying to get this off your record for the purpose of insurance. So there's a whole separate system set up to keep track of your driving offenses. But let's say that was something you were interested in trying to cure and to get rid of that information. You probably can't get rid of it for third parties. It's very difficult to do it. We need legislation to take care of that. Right now, it's an unregulated area, and expungements do not deal with it.
Well, how about if you had a public drunk 10 years ago and it still shows up, but you did your sentence? Is there some way to get that off your record?
The public drunk?
Or it doesn't show up every time?
Well, if you were
looks into it?
Yeah, if you were convicted of it, are you talking about a Tennessee conviction?
Yes.
If you're convicted of it, and most offenses, there's some exceptions, but most offenses, if you have a conviction that you pled guilty or were found guilty of it, it's going to be on your record unless there was what we call diverted, or if it's one of those offenses that you're allowed to take off. And there's a specific section on. We could talk about that. If you wanted to call our office at 756-6400, we could do that, discuss that issue with you. But generally, it's going to be on there. There's not a good way to clean that record up.
An actual conviction can't be taken off.
There are some that can. There's a gradient that deals with the amount of time that it was on and the nature of the conviction. But that has to do with specific legislation that was passed several years ago. So, caller, if you want to talk to us privately about that, we can discuss that issue with you.
Okay, thank you.
Okay.
All right, thank you, caller. All right, Clay. Now we were trying to get back to maybe moving the topic a little further, and let's move into the Second Amendment. Now, the Second Amendment is for many of us, we hear about it, and we talk about guns and the right to bear guns, but it actually says a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Now, that's clearly what the Second Amendment says.
It does, and almost every state has one also. Tennessee's got one that does pretty much the same thing. I can read that to you in just a minute. Bottom line is, people need to remember the background for this particular amendment. There are a number of people that argue about this, but I think the primary thing is to remember that soldiers were quartered in people's homes. There is a specific amendment that deals with that. But as part of that, because you always had to defend and you had the issue of tyranny, there was a recognition that an armed citizenry is the best protection against tyranny.
Well, and there was also a spirit of compromise in that coming out as well, because you had people who were looking at the federal government taking total control of the military, pretty much for the country, and the states' rights people were saying that caused concern. So by giving the right to the citizens to have weaponry and to bear arms and not have that taken away, gave them some compromise from the standpoint of, because remember, this country was new at the time, and to give the right of the military entirely to the federal government was a little bit of a problem for the various colonies that had become states.
I would agree with you, Jim. And so we're talking about, it's become a hot topic in the last several years, really, you could probably say the last 50 years, and that's the issue of gun control. Gun control really began back in the 1920s and 30s. And the error that we had with regards to prohibition that caused the rise in violence and organized crime, the response to the government was that we're going to use the ability to control and to regulate firearms to protect ourselves. And one of the things, you have the image of the Tommy gun, 45 caliber Tommy gun with a rotating canister that allowed, it's basically a machine gun to be able to be fired, and Al Capone riding on the outside of a deluxe Chevrolet and shooting the bank up. Well, so the government first began regulation with the National Firearms Act, and the things that it focused on was who can buy firearms and what kind of guns could you buy. And the reason being is that you don't want certain classes of people buying firearms, and you don't want to have certain firearms being sold.
Any of the things that we've done in this country address what just happened in Las Vegas?
I think it does because the person that firearms went through all of our firearms laws and was one of the persons who was allowed to purchase firearms. So the question being, and I think, it was asked to certain senators about whether or not there were any laws that could have been passed to prevent the Las Vegas shooting. And I really don't think there were, because this is the kind of person that would have been allowed to purchase firearms. If you'll recall, he was a former employee of the IRS and worked as a post office employee. So he was the kind of guy that our government at least thought was trustworthy.
So basically then, unless we just do a total bar on citizens owning weaponry, he would have had his weapons, and Las Vegas would have occurred either way.
I think so. And, the question now becomes about the issue of the bump stock. The bump stock was approved by the ATF as a regulation under President Obama. Bump stock, I've seen other people describe it. You could do the same thing with a very stiff rubber band, essentially to hold the firing position in the trigger mechanism to the point where it almost fires, and you just put enough pressure on it, it will recoil and fire again. So you're not going to get rid of that concept if you wanted to have something like that. But the idea that we can, like the bump stock that can allow simulated automatic fire, is something that the spirit of our national firearms laws would certainly raise a question about why it was approved in the first place.
Well, if we limited all citizens to buying only bolt-action weapons, wouldn't that stop it?
It could.
I mean, because then you don't have the gas recoil. You're actually having to work the bolt.
It could. I mean, and so the focus has been on.
So, assuming I was a victim, if my wife or my brother or my daddy would have been saved by limiting the bolt action weapons, shouldn't we do that in America?
Well, I think that's one of the arguments, is that what is the necessity of having guns to begin with? We've already mentioned one of them. What's the focus of our gun laws? That is, and I think you can look at it most of the time, the reference or the spirit of these laws has to do with allowing Americans to have sporting weapons. And the contraindication is not to have military style weapons. So military typically are going to be viewed as weapons with special characteristics to them. For instance,
automatic or semi-automatic.
Well, every bolt action rifle is not something you can purchase either, because you may be able to purchase, for instance, a 50 caliber Barrett, which is, the Tennessee state weapon. That weapon is a long rifle and it's 50 caliber. Why does someone need to purchase that? It's a military weapon. You're not going to shoot a deer with a 50 caliber rifle ordinarily, because the range on the thing is miles. So the question always comes down to what's the purpose, the spirit of the laws in terms of the restriction on our amendment. And our amendment is the recognition that we have the right of self-defense, and that self-defense is self-defense in the face of tyranny.
Right. So it's not just self-defense from your neighbor or the person breaking your house. It's from the federal government itself.
That's the primary issue. And I think certainly our laws recognize that, it's a God-given right. It's a God-given right to defend yourself. So you certainly couldn't say that it was strictly limited to the opposition of tyranny, but that is the greater purpose.
All right. So what regulations then have been in effect, and what restrictions are reasonable to put on a Second Amendment right to protect myself and to protect my family?
Well, and so here we are, Jim. We're faced with the restrictions that are contained in the National Firearms Act. Also, if you wanted to take a look at the Gun Control Act of 1968, which is an amendment to the National Firearms Act, the Assault Weapons Ban, and the Brady Handgun Violence Act, basically those three acts combined together to create restrictions on who can buy guns. So the number one thing is that you can't have felons or people who are prospective felons purchasing a gun. You ask about the Las Vegas shooter. That wouldn't have had any effect on him. He had a record that was free of any criminal activity. So the second thing is you can't have someone who might have a criminal crime. That is, they might be indicted. Well, he wasn't someone that was involved in that, wasn't going to be indicted. The second part of it is mental competence. So the Brady bill was, if you recall, after John Hinckley shot President Reagan, there was a push to have restrictions on who could purchase guns, primarily related to their mental competence. Well, in this particular instance, there's nothing to indicate that this particular shooter had any mental incompetence, though he may obviously had a black heart. So, but there's a difference between mental incapacity and a black heart. So that wouldn't have come up either. That's the best effort that the minds of our country have come to determine whether or not there should be restrictions on who can purchase a gun. And those two primary ones are it. There are also restrictions. For instance, in this day and age, we're talking about aliens. That is the illegal aliens, not the flying UFO kind, that they can't purchase firearms either. And those
the UFO can?
Maybe the UFO could. I mean, they could probably, if they've got that technology, they don't need them, I suppose. But we're talking about those who are not United States citizens. They're not permitted to purchase firearms. And then finally, there's an age restriction. The age restriction prevents the purchase of firearms in the form of a handgun from someone under the age of 21. And then a long guns, which respects our tradition of hunting, age of 18 and under. So minors can't purchase firearms. Certainly the long gun variety, there is a little bit of a leeway in terms of the age that they can purchase those guns, and that includes ammunition. So none of those restrictions would have had any effect in this case, particularly in light of the fact that the unusual characteristics of this firearm purchase related to the bump stock.
Well, Clay, I think we're at the end of our show, and we'll have to take this back up next week and have we try to finish this discussion. This is Jim McCoon, Clay Whitaker with Legal Bytes. Thank you for listening.